Hello, my name is Phillip Johnson. I'm an Associate Professor of Intellectual Property Law at University College Dublin, a Visiting Senior Fellow at Queen Mary, University of London, and I'm one of the two authors of the International and Comparative Law of Patents, Trade Secrets and Related Rights course on the London International Programme. The other author being Professor Johanna Gibson, the Herschel Smith Professor of Intellectual Property Law at Queen Mary. This course deals with two things. It deals with patents and it deals with trade secrets. And it looks at the questions in an international and in a comparative way, which means in the first section, Section A, you have an introduction to the history and justifications of the patent system, looking about why you have the system and the advantages and disadvantages. And then it takes a comparative law approach to consider the basic questions relating to patent law, such as what is patentable? Is something new enough to be novel? Is something inventive enough to have an inventive step or be non-obvious? It then looks at the excluded subject matter. Is there something which can or can't be patentable by its very nature? It looks at infringement and it looks at employee inventions. And for each of those, it does it through the lens of 4 jurisdictions, primarily through the United Kingdom, but then the United States and Japan. But also, importantly, because the United Kingdom is part of the European Patent Organisation, much of the UK law is harmonised with other countries in the European Patent Organisation under something called the European Patent Convention. So much of the discussion will relate to the European Patent Convention itself. Section B looks at trade secrets. Now, trade secrets can be very, very important. They're often used as an alternative to patents. In other words, you didn't want a patent, you keep it secret instead. And the law enabling people to keep those things secret is the subject of the second part of this course. And this looks at a number of jurisdictions again. It looks at the United Kingdom, the United States, France, Germany and Japan. And using that comparative approach, it goes through the different ways that they consider issues of trade secrets. There's a very, very different approach in the United Kingdom under what's breach of confidence than there is in the United States under the Uniform Trade Secrets laws, for example. The third section, Section C, looks at the international aspects of patent law. This is because there's a number of conventions which have implications for patent law. There's the regional conventions, such as the European Patent Convention, the Eurasian Convention, some of which are already studied in Section A if you do that as Section C as well. But also there's international conventions relating to substantive patent laws, such as the TRIPS agreement, fully known as the Trade-Related Aspects of Intellectual Property Agreement, the Paris Convention, which sets out certain other rules of patentability. And there's also certain mechanisms for making applying for a patent easier, such as the Patent Cooperation Treaty. Those international agreements are the subject of Section C. Section D, called Special Topics, looks at certain aspects of patentability and patent-related subjects which have a more detailed consideration. The first part of that will look at utility models. Some countries have laws which have petty patents or utility models. These are things where the patent protection is of a lower level and it's easier to get than a conventional full patent. And in that subject you'll look at some of the countries which have different models and answer questions about whether it's a good or a bad thing. Here, because there is no petty patent in the United Kingdom and none in the United States, it tends to be looking at a proposal for the EU petty patent some years ago and the approach used for France and Germany and Australia where petty patents are granted. The second thing that's looked at is the patenting of biological material. This is a particularly tricky and controversial area. There have been disputes in the Court of Justice and elsewhere about whether stem cells and products of stem cells should be patentable. But also there are difficulties about biological material generally. How do you determine whether something is disclosed for the purposes of patentability? How do you determine whether something is infringed if it's biological? What about self-propagating substances? That sort of thing is studied in the chapter on biological material. Another particularly tricky area for patenting is the patenting of computer software. Some international conventions, such as the European Patent Convention, seem to suggest that computer software isn't patentable, although in fact it doesn't work like that at all and never really has. And there has been a long series of cases and disputes trying to work out exactly how the exclusion or the restriction of non-invention computer programs actually works. The next subject you'll look at in the special topics is plant variety laws. And these again, this is a brief introduction to plant varieties. It could be a very substantial part of the course, but it's only a brief introduction to the various approaches used in the United States and Europe. The final special topic that you'll look at relates to the quality of patents. This is a much more policy-based question. In recent years, there's been an increasing concern that patents are granted for things which are of a very low quality, a very unsatisfactory grant. And this chapter will examine the questions about how maybe patent quality can be improved and what really questions about patent quality are actually about. So over the 4 sections, you should have a good understanding of patent law and trade secrets across a number of jurisdictions and with their international remit.